Hello and good afternoon, everyone. We had so far such an enriching day of conversation about everyone's favorite topic these days, particularly around the 28th of January, data protection. We have the honor of being the last panel of the day, hopefully putting together threads from all of what you've heard so far today and answering perhaps a rhetorical question. Our panel will aim to answer whether we are reinventing data protection. So that's the title that you've seen in your program. And I am very happy to welcome, I was about to say old friends, but just very happy to welcome excellent data protection experts for this session now. So let me make sure I have everybody's right affiliation and job title. Johnny Ryan, very happy to welcome you. Johnny is Director of Enforce at the Irish Council of Civil Liberties. Very happy to also have Nora Niloidian, who is Senior Lecturer and Director at the Information Law and Policy Center at the University of London. Welcome, Nora. Then Hilke Heijmans, who right now is the chairman of the Litigation Chamber and member of the board of directors at the Belgian Data Protection Authority. Welcome, Hilke. And last but absolutely not least, Karolina Mozjesovic, deputy head of unit for the Data Protection Unit of DG Justice at the European Commission. We have here a wealth of experience in data protection. Everybody in the panel has been around in the field and at the CPDP conference for many years, having different roles in different hats. So perhaps it's the best lineup to discuss whether we are reinventing data protection and to kick off the question. I'd like to look back a bit, actually, back to 2009, when there was a volume collecting papers from the CPDP conference, which was named that year Reinventing Data Protection. So as you've seen, we've been talking about this for at least 16 years now. And just to highlight a couple of the ideas that have kept us busy since then, I looked at 2 or 3 chapters, and one of them is titled, in that book, one of them is titled, The Right to Informational Self-Determination and the Value of Self-Development, Reassessing the Importance of Privacy for Democracy. Well, I think this is, it's more needed than ever to talk about this. Another very interesting chapter in the book is Who is Profiling Who? Invisible Visibility, from Professor Mireille Hildebrandt. So, is it the time to reinvent data protection? But before going into that discussion, perhaps we should assess what the GDPR has been doing so far. The GDPR being the latest attempt of the European Union to reinvent data protection. And to this end, I would like to ask all of the panelists to be both positive and negative, and I think that's very important to look at what's been going well and to also look at what has not been going so well. And if you could potentially pick one positive effect, one positive thing that the GDPR had in making data protection more effective in Europe, and one thing that you believe didn't go so well. So, Johnny, perhaps we start with you, with the 2 perspectives.
Okay, thank you very much. And it's a pleasure to be back. I remember last year in a similar chair, same event, different venue. And you and I were on the panel, and it was Anna collapse who was asking us similar questions. And at that time, I think I said, I want to see data protection become strategically responsive. Now, in the interim, what has happened is the costs of having allowed a small handful of oligarchs to take and maintain control over our infrastructure, our media, and our feeds that shape the politics in our democracies, those costs are now becoming undeniably too high. And I want to see data protection become strategically relevant still. So I don't want to give a critique of how we got to where we were, how we got to where we are, or give out about where we are. I want to say that for all of us, everyone in this room has a stake in confronting the reality that we find ourselves in today. And that reality is manifest in Germany. It's manifest in the UK. I can see it in Irish politics. We have an administration in the US that is actively aggressive, and it now has those tech oligarchs as arms of itself. We need data protection to protect our democracy. So I want to see it be strategically relevant. And I don't think we get there by critiquing how we got to where we are now. I think this is about being serious and acknowledging the acute hazard that we find ourselves facing. We have, I'm not sure what the scenarios are, somewhere between 3 and 12 months to avoid total disaster. And I don't think that lesson has quite sunk in yet, but I hope it will.
So this ties in very nicely with one of the parallel sessions that just ended, where the conversation was about what is data protection protecting. And Johnny, your insight that it can protect democracy itself is quite interesting, heavy, and scary and very relevant. So thank you for that perspective, Nora.
Well, just first of all, I'd like to say thanks so much to all the organizers for this really fantastic event. And it's wonderful to be here on the panel. I'll continue on in the very optimistic vein that Johnny has begun this panel on. But I'd just like to start in going back to a comment that another speaker made in a previous panel, which was that GDPR is the golden age. It was the Renaissance compared to what he considered to be a wave of quite demanding and quite complex recent pieces of legislation that I'm sure this audience is all very familiar with, DMA and DSA and data governance and the AI Act, of course, and so on, which is that for the question of enforcement, when the GDPR was enacted, that was a huge, huge shift. Now, we've spoken a lot today about how procedure around that can be changed. But the fact that the GDPR created this level playing field for data protection authorities across the EU really, I think, has been not that appreciated of late because the legislative environment has become so complex and so interconnected. But the fact that, and I don't know if anyone's had the chance to bring it up yet, but the academic from the University of London will, before Brexit, when we had 28 members, it was the most incredible controversy that when we had the Cambridge Analytica scandal, the most that our UK Data Protection Authority could do was to issue a fine of £500,000. So for a company like Meta or Facebook, as it was then, going back in time, you can have the discussion about deterrence. You can have the discussion about how strategic data protection needs to be. But we did have unreasonable limitations on the enforcement arm of data protection law in the EU. And that changed under the GDPR. And I really think we should acknowledge that. On a constructive note, to be a bit critical of what's happened since, you can only, I think, take a step back to look at all of the additional responsibilities and additional frameworks that data protection authorities now need to be considering and now need to be interpreting the GDPR alongside of. And in addition to all those additional responsibilities and that extra layer of compliance and all of those additional responsibilities on top of all of the existing responsibilities they already have under the GDPR, corrective powers, investigative enforcement, sanctions, and so on, there has not been the same level of support in terms of providing additional capacity for data protection authorities as is absolutely necessary. And to go back to a positive note again, I think it was very, very significant that there is an explicit legislative requirement in the GDPR that data protection authorities at DPAs, that they have those resources, those financial resources, that staffing, and also crucially, that independence. And because this is a fantastic event co-hosted, by both the EU and the Council of Europe, I think it's important to acknowledge the encroachment upon the independence of data protection authorities. And we had a huge scare in the UK with that last year, with a data protection bill that now no longer exists because of a change in government. But those encroachments are still there. So enforcement really matters, and the enforcement arm of the GDPR and the data protection acquis more broadly really need to be protected and safeguarded against.
Thank you so much, Nora, for this perspective. And I think it is remarkable that in your top answers, what went well, what happened well after the GDPR, and what could have been better, you have in mind the role of the data protection authorities and enforcement and how enforcement is organized. And you're not spotting issues with the core principles or some of the rules or how they are working in practice. And I think this is a great segue for Hilke, who is representing a data protection authority. And perhaps you have a perspective on this as well. But also, of course, if you're looking at the substance of things, that could be very interesting to hear.
Thank you very much, Gabriela. I'm very happy to be here. I'm honored to be here in front of this enormous crowd. I'm also indeed someone being around in CPDP for ages, like you and some others here. So it feels at home. But our challenge is not at home. It's what to do in a much wider scale and how to ensure that we remain effective also outside. I would say, what is the goal? We were in another panel which said, what is the goal of data protection? For me, I would give a bit of another emphasis to the goal. What should be our compass as authorities and also as society working on data protection? I think, first of all, we are there to protect citizens. Individual protection remains our main starting point, I would say. And individual protection, you don't do that just by handling complaints, but by all the things we do, and also by ensuring that we act in a strategic manner. Individual protection does mean, for me, mainly fairness, the right to be treated in a fair manner. It doesn't mean that everything is subject to individual control and that consent should be everything. Secondly, so for society, for the individual, but also for society. Contributing should be our role, contributing to a responsible digital society, including AI, fully protecting fundamental rights, democracy, and the rule of law. And I think the rule of law, our role as a data protection authority under the rule of law, having the mandate by the European treaties and also by national constitutions and laws to provide protection, I think that should be leading, that we should be doing. Third reason, third compass should be Europe. In Europe, we need coherent protection. And I think we are not yet there. We see fragmentation of the way we apply the law, in the way we enforce the law. And I think progress is being made. Progress is made, but it's not enough. But we see a lot of progress, of course. And we see there's a tremendous amount of case law by the European Court of Justice, which makes clear, which gives legal certainty, the legal certainty where many people always complain about that that's not there. But I think a lot of legal certainty is there by what the data protection authorities do, the EDPB guidance, the EDPB decisions, and also what the court does. The other point for Europe fragmentation, I said, the other point which Europe was doing was guiding the world. The Brussels effect. We've been talking a lot about it for years lately. The fact that companies take the Brussels rules because they give the most certainty and because they provide for the rules which make the economies work. But there, I think, and that's a bit follow up on what Johnny already said, we should be very careful. What I hear also when I talked yesterday to companies, less and less I have the feeling that these Brussels rules are necessarily then compass, and that's something we should be very, very, very clear of, that we should work on that. Finally, about DPAs, I thank Nora for her support. We would also like to have more staff, more people working on it, etc. But also, I think we should also, as DPAs, work in a strategic manner, meaning that we are not political bodies. We are there to protect data protection, to ensure data protection. So we're not necessarily the bodies that protect all fundamental rights in our societies. So we should be modest in the scope of what we do, but what we do, we should be very effective, enforcing, and strategic. And strategic means for me, and that's a reaction also to what I heard earlier today, for me is not that we handle all complaints in time. No, strategic meaning that where there's the biggest risks for society, that we act. So in a strategic manner, and I think there the EDPB should also step up. Stepping up, we did that 2 years ago, 3 years ago in the meantime in Vienna. This Vienna process, I think, was a great help for the EDPB. And I think now we're in a further stage where we should step up and maybe really do enforcement together in a more coordinated manner. The procedural regulation helps us, but there must maybe be more of it. I think this as a starting point, the overview, individual society, Europe, not to be missed, and then the role of the DPAs.
Thank you very much, Hilke. And the fact that you bring society into what you already see that is the role of DPAs and of data protection to protect in addition to individuals, I think already answers a bit one of the questions about whether the data protection regime should be updated, reinvented, because we often hear the criticism that it only concerns the individual, and some of the biggest challenges right now have societal effects. I personally also happen to be on your corner there, thinking that data protection protects a bit more than just the individual rights. You've also talked about systemic risks and systemic, again, risks that data protection addresses. But as we've seen in the past 5 years, the European Commission, the Parliament, the co-legislators here have found it necessary to adopt new rules to address systemic risks that perhaps you also had in mind. So I'm going now to Carolina, and before moving to our next round of questions, which will be on the data strategy package and its role there, Carolina, can you share, in your view, what was a positive effect of the GDPR, what didn't work so well so far, and perhaps this will segue to the next round on why was this new package of data laws needed in the end?
Thank you very much. Thank you very much to the organizers for having me. It's really, as you said, Hilke, an honor. And I'll not say that I'm here for ages because it will appear that I'm a dinosaur, but it's the last thing we want. But well, I think that the subject matter develops, and although we are meeting here regularly once a year, we have all these new topics and new societal issues touching upon the data protection world somehow. So thank you very much again. To your question, good and bad things. What did we achieve? What is the main achievement of the GDPR? I think that for me, it's really, and I will not say to the Commission, but I think it's also transpires from our communication from the last year. It's really this raising awareness, and both to our citizens, residents, and to the companies. So it is, and it's probably also accompanied by the technological developments, and but it's the most important thing. All the other things around, be it modernize the governance, a new system of enforcement, whatever there is, for me, it's really secondary. It's this, and I understand none of the speakers challenge that, and what you also underlined, it's the rights, they stand. The structure of independent authorities enforcing, it stands. And you underlined it also, Nora, how important it is, how the tasks of the authorities are also becoming, or cross regulatory nature of their actions is becoming more and more pronounced. So yes, this is for me the main thing. Now, what did not work? And we can, I will not speak about issues which we already addressed, like maybe more streamlining so that the enforcement can be more effective and quicker in cross-border cases. But I think that it's something on what we all have to work, is to put more, or to own the risk-based approach, and to own technological neutrality of the GDPR. What do I mean? And I think I'm going back here to something you said, Hilke. I do think that GDPR is not only about data protection. I do agree, but it's therefore, I think that the data protection authorities have to balance, right? Because otherwise, it will be only during the litigation that the impact and balance between different fundamental rights will materialize. So for me, recital 4 needs to be really given importance. And fragmentation, you mentioned it. And I think here, work in progress. We've noticed that for the sake of legal certainty and in the light of certain developments, there needs to be a more targeted approach and more specification, let me call it, of the application of the GDPR in certain areas. What we did, not only via what the member states do via the possibility to really specify the application of the GDPR, but also we with platform workers regulations, with addressing political advertisement, also addressing or adjusting some GDPR flexibilities and solutions in the DSA or the DMA, right? Bearing in mind one specific, in the DMA, specific size and market power of the gatekeepers, in the DSAs, the specific placement of very large online platforms or search engines. So this we did, but this risk-based approach also when interpreting certain notions, which is I understand that probably, and I've heard today an argument advanced that it's embedded in the GDPR. Of course, it's a development case by case. The case is developed and a notion is interpreted in a specific case. And then it goes through, it's being checked by the court. But since these big cases address sometimes very big operators, we are getting some interpretations which are very much tailored on very specific ways of processing, right? And the court refers to a scale of scope of processing, which is very unique. And this interpretation, this case law and this cases adopted by the data protection authority stained the interpretation of whole notions throughout, notion of consent, what can be done on the contract, and so on and so on. When the interpretation was done, in a very specific context, bearing in mind specificities of one operator. And I think obviously there will be more cases, more judgments coming, and giving the depth to these notions, which are flexible. And I think I'll stop here.
Thank you, Carolina, very much. And you did bring some new dimensions to this brief assessment we did here about how the GDPR has been going. And it's interesting you brought up the risk-based approach and even consent, even if it was as an example. But I want to push a bit the panel to think about the rules on content that the GDPR has brought and whether we should be rethinking them in a way or another. And particularly when we're looking at consent, transparency, user control, should they be redefined? Do they still designate that informational self-determination that we saw, we were talking about already for many years? Are there things we can explore here when it comes to the rules of the GDPR and whether it's time to shape them in a way or another? Again, consent, transparency, user control in this day and age. Is there? I'm. Is there anyone who would like to take this?
Will I take a crack at it? Oh, so this is pay or okay, is it?
No, not necessarily. It could be. Yes.
Let's imagine you're asking about pay or okay, which is what I assume. I don't understand this entire debate. I've worked for a publisher, I've worked for an ad tech company, and I know what is being requested when these consent messages are generally shown. What is being requested is your consent to a data free-for-all. So I've never understood how we found ourselves in that discussion. Now there's an industry and political discussion which is about the relative power that the publisher has with respect to the ad tech intermediaries. That's the real conversation. And whether the publisher understands just how disadvantaged they are by the current technology. This would be real-time bidding, a topic that just won't die. You know, I don't know how many times it needs to be shown that publishers are enormously disadvantaged by the loss of their audience data into the ecosystem where it can be monetized by clickbait and by data brokers. So there's no way to convince publishers, or most of them, not to ask for this consent for the data free-for-all. What then alarms me is that we end up having a conversation about whether they ought to be allowed to, and this strange fudge that we got from the EDPB, where they couldn't quite say no to some publishers who insist on this act of self-harm, partly because they seek to ape the ad tech intermediaries. And in the case of some of the biggest groups, have acquired ad tech units, right? So they're partly in that business. That we're still having this debate about whether an internet user can be forced to consent to a data free-for-all, which is well understood. I mean, there are paragraphs of Helke's decision in the IAB Europe case, findings of fact. You know, no one's questioning those findings of fact. So I don't know how we are having a debate about whether we should have a consent gate for that system. Now, there are some other things that you can ask for consent for, but fundamentally, that's the main thing that consent is sought for. I don't know how we're still having that conversation. It's so obviously impossible.
So you see, this is interesting, and this is why data protection will forever remain my most fascinating topic to think about, because you immediately thought about pay or okay, but if you're thinking about consent, transparency, individual control, you can also have in mind what I had in mind, which was particularly the AI debate, agentic AI and all of these things, but absolutely valid route to think about when you're speaking about consent, individual control. Should we continue to expect from individual to assert that control over their data? Just super briefly, and then we'll go to Carolina.
Super brief one on AI. The big news in the last few weeks on AI are the leaps that the Chinese have made with DeepThink, but actually a few other models, and one just announced in the last week from Hong Kong. And this is causing a huge rethink in the US about their current approach, which is take loads of data and just crush the hell out of it and see what you get. In the US, one side of that rethink is, oh my gosh, we have so much regulation in the US on AI, it has stifled us, and that's why the Chinese are ahead. In reality, Chinese AI is heavily regulated. But so it's a really interesting model of the regulation with robust enforcement equals innovation. It's an interesting thing to bear in mind.
It is absolutely interesting, and it's true that there are many regulations on, also specifically on recommender system and generative AI in China, but there's of course also the question of enforcement and how those are taken seriously or not. Carolina.
Yeah, well, I agree with you, Johnny. What doesn't happen that often, but yes, very much appropriate, good regulation is something that foments innovation, because it's an innovation in legally certain environment, right? Where the legislator already balanced between different, aims, pursuit, and values, and whatever. But I wanted to come back to on your comment previously on this consent, because you started and there was the whole argument and discussion on pay on consent. Because for me, when I hear consent, I hear much more the consent in the context of research. What do we do there? Right? And how does it work? How do we work around research on sensitive data? What are the possibilities? So for me, it's not so much only the, right? And it's a very complex matter which needs to be addressed when really very important considerations need to be taken into account. We addressed it as far as health data is concerned through European health data space, so that we enable research in this secure environment where we balanced, bottom line, between the rights of individuals and the right or the need for the society to process the well-being of all of us, right? Because the health, the research on medical research is supposed to serve all of us. Here we go back to the discussion, what is research, but we have a fairly strict definition of that. So I think that in general, and another comment, it's we are a little bit concerned that now it seems that consent is the best legal basis, the most secure. And it was, and we are very worried about it, because they are 6 legal bases, and they all have equal value from the point of view of protection given to an individual. And controller should choose which one is appropriate. And indeed, the situations are very different. Right? And consent by no means is the most appropriate legal basis in a lot of situations. And I wonder also if in a very quick environment, online environment, when the decisions need to be taken or taken sometimes very quickly because the consequences are not really felt, consent is the most appropriate tool to protect the fundamental right of data protection of an individual. See, if an individual will be always able to take this decision, and I don't want to be patronizing and take it away that people are not able to do that, but this is probably a little bit different discussion.
Yeah, Hilge.
Thank you very much. I thought I agree with everything you said, Carolina. But then in the end, I thought no, because I think especially in
I don't know how we managed to do that, but
especially in this very quickly changing and very quickly society who acts which are required very quickly, individuals need to act very quickly if they want something or not. I think consent is not always the best legal basis, or by necessarily it's not the good legal basis. So I think.
But then we agree.
Do we agree?
Yeah, exactly.
That's better, even better. But we are not here to discuss our discussions over the last 10 years. But
No.
we could do that. No, let's come back to it. We come back. The discussion whether or not consent is a more important legal basis than other legal bases is something which continues to be part of our DNA as data protection lawyers. We never come to an answer. I thought I gave the answer 10 years ago. No, the 6 legal bases equally important, but it's not evident still. And that's not the point. We can disagree. We should discuss, continue discussing what we exactly want to protect. But I want to take on something else. How do we ensure that laws and the interpretation of the law and the application of the law do what we want it to do, namely to ensure that all these new technologies, which are developing in any case, are developed in a responsible manner. In what way can laws can contribute to that goal? That can be done in different ways. That can be done by specific laws, for instance, in the digital health space. It can also be done by putting much more emphasis as authorities or also as others on notions like data protection by design, by data protection by default, by DPIAs, making that part of the law really works, so that from the beginning also helped that from the beginning we ensure that we accommodate as lawmakers, but also as enforcement agencies, to ensure that the ultimate goal to ensure that the new technology is accommodated by appropriate laws and is done in a responsible manner, that works. So I think that's an important issue, and I think one of my points has always been data protection should not be seen as a stopper of innovation. Data protection should be seen as an enabler of legislation. This is a very general point, and of course you could just discuss about it for ages. What does that mean? But you should always have that in mind, that you want to enable technologies which are useful for society, or that maybe are unavoidable because they happen in any way, to ensure that they, when they are enrolled, that is done in a responsible manner. Last point, maybe, what for this moment, I think sandboxes indeed is very good. And final last point, we should work together. That's the concept of the digital clearinghouse. I don't know if that comes back in this discussion again, but I think we should not. We should always emphasize the notion of this digital clearinghouse, of really working together with other types of authorities, not only in the policy area, not only when talking, but also trying to start enforcement together, which is very difficult because then the lawyers come in and they tell you that procedures are not the same, etc., etc. But I think that's a final point I would like to make at this stage.
Thank you so much, Hilke. And just to point out, Nora, that I remembered in my first CPDP 10, 12 years ago, we shared a panel. And in that panel, I was presenting a paper on forgetting about consent. That's literally the title of that research paper. Nora, what's your response to the points made by Hilke and Johnny Carolina?
That I disagree with them completely. No, I don't.
Like, finally.
I was actually going to follow up on a point that you made earlier on, Gabriella, and I think it's with regards to the fact that while I am not advocating the reinvention of core legal basis or principles under the GDPR, I do think that the protection of them is something that we're going to have to reevaluate now on a very case-by-case basis in the era of AI policymaking. And this goes to the reference you made to agentic AI and companion AIs. And we talked a lot today about, big tech companies. And, there are some very significant companies out there providing virtual reality experiences and augmented reality and also digital assistants, generative AI, and many more services. But there are those companies, small to medium companies from any particular region in the world that have very little consideration for GDPR compliance and compatibility. But the access to those products, companion AIs, it's so easy now, particularly for very vulnerable individuals, particularly for children, particularly for teenagers. And when we think about the essential components of consent, meaningful, informed consent, that means very little to someone who doesn't have the capacity to make those informed choices. And we have seen the consequences of that in some very concerning ways. There was one particular teenager in the UK who was very influenced by a companion AI's recommendations that he should indeed kill the Queen. And this was in the prosecution file afterwards. He was underage. And the reality is that you cannot expect the guardians of a young child or individual to be monitoring every time they access the internet. Yes, you can have historical supervision and checks, but you can never be monitoring all the time in real time, which means we need other mechanisms. And I think we've seen a manifestation of that under the AI Act, where you have those hard red lines, where you have prohibited AI practices. And I think we're going to have some really interesting and possibly very difficult conversations going forward as to how that list of AI practices is going to be reinterpreted or expanded as the legislation allows us to do.
Thank you so much for bringing this up with the AI Act and the hard red lines that could potentially be an inspiration for more effective regulation, even in the data protection world. One of the questions I was hoping for the panel to look at is exactly about whether there are other lessons that we can learn from the new digital laws, from the Digital Services Act, from the DMA, from the AI Act. Have we seen some new policy answers from which we can learn in the data protection world and make data protection more effective? And this is a prime example, and perhaps you want to add additional ones. I'm not sure. Maybe we should do another round. And in the meantime, please prepare your questions because we will have a bit of time for Q&A at the end. Johnny.
I think the lesson is speed and the lack of it.
Sorry, can you say that?
I think the lesson is speed.
The lesson is...
And the lack of speed. There has been a narrative, a narrative for quite a while, that if we take enforcement from the capitals and centralize it, that will make all of the problems go away. And although I've been very critical, with sustained criticism, of Ireland, Luxembourg, key member states as lead authorities, I've never advocated for bringing that power to Brussels or to one agency and centralizing it. And there's a reason for that. We haven't seen in the digital domain, I don't think, the right pace and urgency in Brussels either. Now, I don't want to diminish. I said this isn't the time for a critique. This is a lesson, not a critique. It sounds like a critique, but actually I'm trying to make it as a lesson. I think we are in a very, very acute moment of crisis. And I do not hear anyone on the DMA team in the Commission, in Connect or in Comp, talking about interim measures. No one talks about interim measures. I don't hear anyone in the DSA team talk about crisis response mechanism. There's none of that. Now, I think we are in a crisis. I think it'll be impossible to deny, if things keep going, very soon that we're in a crisis. And I think we've been in a crisis for some time. So if you believe that these tools are effective, We've got the GDPR. Sorry, I should say effective to tackle the manipulation machine, which is now pointed at our throats. If you believe that GDPR Article 9 means that machine shouldn't be on by default, forget about the option to, in theory, switch it off. And the UX will make sure you don't take that option. The tyranny of default will kill that option. Forget about the DSA's opt-out option. We already have an existing law that it shouldn't be on by default, that recommender machine that is manipulating our politics in all of our member states. We also aren't seeing in the national capitals that matter, specifically Dublin, application, for example, of AVMSD 6A, which you could use with prima facie evidence against TikTok now, based on the material that was accidentally unsealed in the US State's Attorney's General case against TikTok. But actually, it applies to all the platforms. So yes, the member states aren't doing it, but also I don't think we're seeing the right urgency in Brussels. And I think the lesson is there isn't a magic formula, right? The member states don't do it. Brussels hasn't yet done it. And the answer is, how do you get all of these tools? And there are many. I mean, product safety might be one as well. There are many tools that we are going to need to use over the next 3, 4, 5 months to defend our democracy. We need to have them all arrayed in front of us. It doesn't matter who has them. We just need to figure out how we execute them, right? And there isn't a magic formula. And so the lesson from the last generation of law is you cannot guarantee that just because you've centralized enforcement, you're going to be able to really rapidly respond when you need to. And we need to start thinking about how you bring the national stuff, keep it in the member state level, keep Brussels stuff in Brussels, but get these people around a table and start thinking strategically about how to defend us against the manipulation machine at a moment of dire crisis.
I keep here strategy, democracy, crisis. These are very, very powerful words, Johnny, and thank you for bringing up this lesson to learn. I see Hilke with an immediate reaction, and then perhaps we go to Carolina.
Yeah, thank you very much, Johnny. I hear this more or less as a question addressed to the EDPB, for instance, or maybe the EDPS as a facilitator behind everything. What I think, and there I agree with you, this is maybe not the time to think about fundamentally changing our legislative models by starting to discuss again the fact whether or not the GDPR should be enforced on a European level. Maybe we should not do that, but what we should do is to see how we can use our existing mechanisms, which are a lot, how we can use them better. And that would be maybe, that's how I listen to what Johnny says, and that's something we should try to think. How can we do that effectively? How can we, with it, if there is a crisis, that's the question to be asked. When we listen to what we hear from Washington, I think there is a crisis, or from other parts of the United States, there is a crisis, but we should first think if there is a crisis, but then I think we should sit together and think, how can we step up what we're doing in a way that is effective in a very short manner, whilst not forgetting that data protection, and Carolina said wisely, it's mainly about raising awareness amongst the big population, it's by helping individuals, etc. That we should also do, but maybe the first urgency to change is maybe to take up this assignment and think, how can we work in a more, how can we address the most urgent challenges? I don't have the answer, and I'm not in a position to do that. I'm just one of the 27 members of the EDPB, 28 members of the EDPB. But nevertheless, I think it's something which we should take on. I think that's for now.
To highlight the crisis point, we had a round of presidential elections annulled in one of the member states of the European Union 2 months ago due to some of the things that have been highlighted by Johnny and so forth. Carolina, so speed is one of the lessons. How to use the powers that these laws confer most effectively is another lesson. What's your take?
Well, I just want to go back. Indeed, there is probably no one-fits-all solution, right? And there were specific reasons why the enforcement of the DMA and DSA, in part, was pulled up to the Commission. There were and are still reasons why the GDPR is enforced in such a different way. And cooperation, which is the must, also not only from the point of view of that the same event is tackled from different angles through different legislation, but because there are such a such overlaps as far as use of certain terms and notions are concerned, right? Just to give an example, consent in the DMA, anonymization in the DMA, fundamental right aspects and the profiling and so on in the DSA. So already because of that. I just thought, to be provocative, a good solution. And since we were speaking about this new tasks for the DPAs and all is the call, and the Commission is saying it's very much behind that the authorities are sufficiently equipped and that they receive sufficient human and financial resources. But we are in the time of cuts. It's also a question like looking at the increases in the budgets of the DPAs. It's sometimes not easy to go back to the member states and plead to still for more, looking at what are the increases in budgets in other authorities in the same member state, right? So this is there. But there is a very interesting solution in the DSA concerning the financing of the enforcement, right? I just, thought about it. And my private thought and reflection, I underline that really. And what else? Enforcement, in particular in area when there is so much self-assessment and accountability is crucial. Nobody will invest in compliance without credible enforcement coming afterwards. Enforcement needs to be speedy, but in order to be credible, it also needs to be, it needs to be more probable than not, and not only 51%, that this decision will stand in the court, because otherwise it will be just a question of freezing certain amount of money on a certain account and I will get it back because this decision will not stand. So again, probably the question of quick but very challenging concepts and decisions to be taken take time. And yeah.
Thank you so much. And to that, I will remind the public that you also were looking at some of the targeted policy solutions and provisions in the new package of digital laws, looking at specific things like political advertising and so forth. Nora, would you want to add something? You technically opened this round of discussion about lessons learned, and you brought up the red lines from the AI Act. Was there anything else you wanted to add?
Yes, I would love to talk more about the AI Act and the red lines therein. I think that to be positive about some of the elements of the AI Act, I think there's two in particular. And coming also from the perspective of the UK, where we have no regime in any way near to some of the safeguards that have been provided by the AI Act, that there are provisions there that I think every country globally would really benefit from, particularly in the age of generative AI and all of these various AI developments we've mentioned on the panel. I think the database register for high-risk AI systems is a very significant requirement under the AI Act. It is so important for transparency and accountability, and it's so important in order to be monitoring how these systems are being used. And having access to those records, A, that those systems exist, B, who is using them. I mean, that is the very cornerstone of how we know what kind of impacts, societal impacts those laws are, those systems are having, but also how we oversee them and how we make sure that the safeguards that are applicable to them are being enforced. So I think that's a very significant safeguard. I was really glad to see that get adopted under the AI Act. I think another very significant provision, although it wasn't in the original AI Act, is the Fundamental Rights Impact Assessment. And I can't see him in the room right now, but if Professor Jean-Claudio Malgeri is out there, I'd just like to commend. Why don't you stand up, Jean-Claudio? So I just want to commend Jean-Claudio and other academics for leading a petition and a campaign to get that provision adopted as part of the AI Act. And that stemmed out of concerns, not just from very impressive academics, but from many in civil society and from many regulators, that the AI Act wasn't taking the rights-based approach that was sufficiently robust enough for the systems it was going to regulate. And it's significant to have it there because for the data protection impact assessment, which of course we already had under the GDPR, fundamental rights impact assessments, A, it makes it clear to all those, not people in this room, but to people outside of this room, that when we talk about data protection, we're not just talking about the right to privacy. We're not just talking about data security. We're talking about all of the fundamental rights that are protected under the EU Charter. And I'm sure many of you, I suspect, have had this conversation with people in terms of distinguishing between privacy impact assessments and data protection impact assessments. But fundamental rights impact assessments, it makes that clear on the very face of it. And that's very important for compliance implementation. And secondly, I think it's very significant that fundamental rights impact assessments also take into account non-personal data as well as personal data. And that's so relevant for large language models and generative AI, where both of those huge types of data sets are being collectively used always. So I think that's very significant. I have to say that in terms of things I welcome a little less, I do think that some of the decisions made regarding what were categorized as high-risk activities were very unfortunate in terms of the decisions made overall by the EU legislature. I think particularly, to give one example, emotional monitoring, where you have no scientific basis whatsoever for its accuracy, is highly questionable under remote biometric identification and Article 5 of the EU AI Act. And there are other powers as well. I'm also very concerned, and for any of you who are here from the last panel, that one of the safeguards that was put in place to allow for law enforcement authorities in certain situations to use remote biometric identification systems in real time, including, of course, facial recognition and emotion recognition, is that they'll have to provide reports, notifications every time that it is used to the Market Surveillance Authority and the Data Protection Authority. And on paper, it's welcome to see that safeguard be put in place. In practice, however, we have a terrible track record of data notifications and logging by law enforcement when it comes to them using very powerful data-driven systems. We had huge problems under the Passenger Name Recognition Directive when law enforcement authorities were meant to provide the same sort of logs to passenger information units, and it didn't happen. So I'm hoping that lessons will be learned in terms of this regime and that safeguard will actually be meaningful in practice.
Thank you very much, Nora. And this makes me say out loud that one of the chapters in the Reinventing Data Protection book in 2009 from the CPDP proceedings was named Data Protection as a Fundamental Right. And it was wrote by Stefano Rodotà. And it was not by chance, because in 2009, of course, TFEU, the new treaty happened, the charter became enforceable, applicable, and we have Article 8 in the EU Charter for the protection of personal data as a fundamental right. So I think regardless of how many times we will have to reinvent or update data protection at secondary legislation level in the future. There are some things that right now are very well established and cannot be reinvented just like that. And we have the wording in Article 8 as such. Now, we promised, it was promised in the description of the session that we will tackle the very important question of whether should the GDPR be reopened and why? Are we on track to achieve the main objectives of data protection regulation without avoiding this important question? And I know we have an answer from this morning, and we've heard from the European Commission, we've heard from DG Just that there is no plan to reopen the GDPR. However, we are discussing of whether we should, not if it will happen. And I would also go back to the same book because it happened to be published the year before the European Commission announced the reform of Directive 95. So see how, in a cyclical way, this question reappears once in a while. Yeah, I'll stop here. And then a very quick yes or no, should it be reopened or not? And we'll go to questions from the room afterwards.
No, we don't have time. We have to break the manipulation machine urgently to protect ourselves. Let me just say, I don't think it's about resources. I mean, there are certain member states where it is, but in my own member state, in Ireland, I think it's just after France or on par with France as far as financial resource goes. We don't need to reopen the GDPR. We need political will from Brussels to finally push the button, to finally get Dublin to apply it. And let me say, that would actually bring enormous competitiveness dividends as well.
Nora, yes or no? Is it?
No.
Hilke?
It makes it difficult for me to say no, but in a more elaborate manner. No, I think we should focus on making it all work better. And I think also that's a point I would like to add. I'm not as short as you, Nora. In this time frame, in this political climate, I think opening up the GDPR would not necessarily lead to the result which all the data protection community would like to see.
So I'll hang on to in this political moment, but of course, hopefully moments pass, and who knows, in some couple of years ahead. Karina.
Should we open still? What is the question?
That was the question, yes. And
well, it was already answered, so no. Right. And for us, it's mainly it's what the stakeholders are telling us, and our internal assessment is that there are so many acts, the solutions are embedded in the GDPR, how the processing of personal data is tackled there, then changing whatever concerns already Article 6 and 9 in the GDPR will have a pollution effect on a lot of other legislative acts already enacted, some still being negotiated. So no, it's a flexible tool. It's a tool which can be adjusted depending on the needs.
Thank you very much for that and for your concise answers. And I'm now going to look for questions in the room. There's somebody in the back, please. And if you could also introduce yourself briefly and then a question.
Hello. I'm Alexandra Stanford. I am from Tilburg University, and I'm doing research on the GDPR and user control. I would like to thank all the panelists for your valuable insights and answering the questions, because I also got a lot of understanding on where the Commission, the EDPS, and all of the other institutions within the Europe mindset is on data protection and innovation. And my question is relating to all of that was discussed today, is that we are mainly, or a lot of the institutions are looking or understanding that their regulation is important for EU citizens and residents. However, as the European Union said that, we're going to innovate, and with innovation comes international users using our product. And with that, all of the institutions within Europe will also be regulating their data. And with that, I think that in this new digital era, that is a positive thing, because Europe is balancing fundamental rights with innovation and ensuring that the environment is protected, people are protected, vulnerable groups are protected, all of that stuff. The one thing that I would like to ask is, as we open our doors to international users using our products, as we innovate, there is one thing that troubles me, is that there is a level of fragmentation within Europe that needs to be discussed in terms of law enforcement, surveillance, all of that stuff. And for users outside of our borders that will be using our products, how does Europe ensure that they have the legal certainty, that they are looked at, and we don't repeat something, for example, like the US, where our data is being sent and there is a lot of confusion as to where they should go and all of that stuff.
Is there somebody among the panelists who would want to immediately take on that? I think the question primarily concerned some differences in which member states in the law enforcement space and perhaps national security space are protecting personal data that are transferred from outside Europe to Europe. Has anybody been thinking about that, and whether you have any comments? How can we ensure that non-Europeans whose data come to Europe enjoy substantive protection?
I'm not that confident we're doing a great job about Europeans' data within Europe, so I don't think we can do that, no.
Short and to the point.
Well, Article 3 GDPR, right? So companies or controllers who are targeting us, who are processing our data, or are processing data through our facilities, need to comply with our rules. It's the question of sovereignty. Possible fragmentation, be it because of the possibility to further specify in the national level. Well, it's the law. I'm not sure I understood fully this the second part of the question, but yeah, we are following the effects doctrine. So we legislate on our territory, and to the extent, also the processing outside has effects on our territory, or we are targeted by the processing outside. I think it's mainly that.
So just very quickly, it's very novel and a really fascinating question to have that inverted. I feel like we talk so much about data transfers to third countries and data adequacy and all countries outside of the EU. But I think if this is an area of interest that you have, I think it would be worth looking at the developments as to how the UK may respond regarding the data adequacy negotiations that will be taking place this year, because of course the UK has also recognized that there are adequate standards for UK's individuals and citizens to be transferred into the EU. So if there were to be some situation where an EU-UK data adequacy agreement no longer existed, it would be very interesting to see what the response could be to that.
Thank you. Hilke wants to add a couple of words.
If I can take the question a bit wider, I think the question could also be seen as a question on fragmentation as a more general problem. And I think that's all true. The GDPR leaves a lot of room for member states, and the law enforcement directive, I think you hinted at that even more, uh, to specify, especially in the public sector, and also the fact that the ways in different member states the GDPR is enforced, there's still a lot of fragmentation. So I think one of the issues, it was also mentioned in the, I think in the Commission report, it was also mentioned in the Draghi report, is the fact that we should further harmonize also in application of the law. The substantive rules, I think GDPR are to a large extent explained in the same manner. That's why we, with all this guidance of the EDPB, and also by the court judgments we have, but on the procedural issues, on how to act effectively enforce, we see still an enormous difference. One point raised by Carolina just a moment ago, one of the different things is, for instance, how national courts look at data protection. There's an enormous big difference in how data protection authorities are scrutinized by their national courts. I can give you some examples of Belgium. Will not do that now, but there is really a big difference in how we are scrutinized, and that makes also that in practice there's big differences.
We have just 1 minute, and I did see a hand. I can promise a question and maybe a one-word answer, but a question for sure, and then we'll wrap.
Very quick question. Simon Ania, I'm a data protection officer. We just heard that GDPR will not be reopened, so data protection officers are here to stay for the future. I'm asking you, what do you think data protection officers can contribute in this new context of which Johnny mentioned, the new digital package? What do you expect? So your wish list, please. And as if you're talking to the empty chair over there.
Would anyone want to try a short, very short answer? And then we'll continue the conversation afterwards.
I've been a DPO. I've lived that. Without any fear of the regulator, the DPO has no internal political power. So it is impossible for the DPO, I think, inside an organization to be effective, even to know what's happening inside the organization, unless there's an external push factor. So you need an ally outside creating fear, and that fear has been absent for a few years, I think.
Yeah, I'm not sure we have a lot. Okay, 30 seconds, 10 seconds.
Not much to add. I think the DPOs have also the best knowledge of the processes inside. Engage with the DPAs, get insight, try to really also make the DPAs aware of your specific processing operation so that you get an answer which addresses your situation. I think.
Thank you very much, and thank you for the question. Thank you all of you for being here with us at the last panel of the day, and thank you to the panelists. This was wonderful. Thank you.